Hello everyone, and welcome back to The Intersection. I'm Justin Luger, partner at Weiss, Serota, Helfman, Cole & Bierman, and I'm joined today by my partner, Roger Pou. Today we have the pleasure of sitting down with Evan Fancher, Regional Manager for South Florida at DRC Emergency Services, a firm that works on the front lines of disaster response and recovery. We're going to be discussing what happens after a disaster strikes, specifically how municipalities and local governments can navigate the FEMA public assistance process, understand their options, when a claim is denied, and what practical steps communities can take both before and after an emergency event to put themselves in the best position possible. Hi everyone, welcome back to the Intersection podcast. I'm Justin Luger. I'm a litigation partner at Weiss Serota. I handle a wide range of cases both on the public and private side, and I feel particularly privileged to be able to be here today on our topic of disaster relief. Being a native Miamian, I've gone through a bunch of hurricanes down here in Miami, including 1992 Hurricane Andrew. I have a lot of personal experience dealing with those issues, and now on the legal side, also have experience dealing with issues regarding FEMA and everything that we're going to be discussing heretofore in this podcast. So I look forward to speaking with you all.
My name is Evan Fancher. I'm the South Florida Regional Manager for DRC Emergency Services. I've been responsible for managing $200 million in debris cleanups across the Gulf Coast over the past 5 years. My first experience with hurricanes in South Florida was Hurricane Irma, where I worked at the County Commission, and I've been working in disasters ever since, and I'm happy to be here.
We're happy to have you here, Evan. My name is Roger Pou. I'm in the municipal division of Weiss Serota. My focus tends to be on municipalities in South Florida specifically, representing them in all matters of general counsel. But due to our experience with Justin and I have had, we've actually also had experience in a lot of emergency debris issues that have come up due to the hurricanes that come up in Florida all the time. And if I could just sort of set the stage here, Evan, Justin and I began practicing in the field of emergency recovery law based on an experience that one of our municipal clients had. For Hurricane Irma, actually, this municipality had to face a hurricane that essentially enveloped the entirety of the state of Florida. And I think everyone in Florida was on notice that this hurricane was going to cause immeasurable damage. And to their credit, this municipality, they did the best that they could, right? In preparing before the storm, they made sure that they had contracts in place. They made sure to document the conditions of their city. But inevitably, once the hurricane came, it devastated them, right? Their canopy was absolutely destroyed. What used to be a beautiful asset ended up being a sort of surprise trap that required extra effort to get into safe conditions to mitigate the risk to the public. Of course, the public expects great recovery efforts from their municipalities, and balancing the need to speed and proper emergency work was extremely difficult for them. So they do the best that they can, and they submit to FEMA through the Public Assistance Program for reimbursement of a lot of the emergency debris work that they conducted. And they were ultimately denied. And Justin and I were then called in to assist them in appealing FEMA's decision. But what we learned along the way is that there are a lot of other things that can be done at the local level to make sure that hurricanes don't end up being a problem beyond that initial impact. And I know you've had a lot of experience as a first responder, really, in dealing with this. And I'm curious, what are the sort of aspects of disaster recovery that you wish your clients might know about?
So I spend my time, when there's not a hurricane outside, hopefully all the time, making sure clients, A, have properly procured contracts, B, they make sure they have a contractor as well as a monitoring firm on contract, and C, and we work on their plans. Do they have proper maps? Are they familiar with the latest in FEMA regulations? Sometimes they change. There are various memos that come out and change definitions. So all throughout the year, we focus on client services so that they're in the best position to never have to call you again.
Yeah, I can actually appreciate that very much. And I know that a lot of the disaster recovery firms that I work with, they are looking out for those issues. You touch on a really important part of the FEMA regulations, which is FEMA requires that any of its disaster recovery any disaster recovery contractor be competitively procured. That competitive procurement process, what is your recommendation to cities when it comes to developing a scope of services and competitively procuring it? Because I know that FEMA regs are pretty strict.
Government's the one place where you can plagiarize and is celebrated, so do a lot of that. Your neighboring municipalities all have contracts. In Florida, I can't think of one municipality that I know of that doesn't have a contract with a decent scope of work. I think the real challenge that South Florida municipalities need to avoid is always going for a low bid. Low bid is wonderful when it comes to, regularly procure services. Say, for example, they need to buy, cups for the city. You can go low bid. When it comes to disaster work, if you get low bid, a lot of times you'll run into issues. You'll have a contractor that's not able to actually do the work or that can carry the financial burden of doing the work while the city hasn't had an opportunity to reimburse that contractor or pay that contractor out, even as the city is trying to get paid back from FEMA. So I tell cities all the time, A, look at what your neighboring municipalities have. B, adapt their scope to your particular circumstances. So some cities have waterways, some cities don't. Some cities have sand, some don't. Some cities have a beach, but the county manages the beach. So there's no need for a beach element to the contract. And stay away from picking 5 contractors. If you've got 5, that means you don't have one. So pick one. You can pick a secondary, a tertiary, but saying, we'll take everybody and then hope somebody shows up or hope somebody works with you in the off season. That's a recipe for disaster.
So I think that's really good information. I know from the disaster debris RFPs, requests for proposals that I've drafted, the RFPs should be tailored, like you're saying, to the communities, and what better to look at than some neighboring municipalities or counties, and obviously tailoring it to your specific needs, right? The waterways, like you were talking about, and price. Price is important, right? FEMA requires in its regulations that price is considered, but it also says, look at other aspects, right? Past performance, the responsibility of the contractor.
Responsive and responsible bidder.
Correct.
Because anybody can say, yeah, I'll come pick up your debris. Can everybody do all aspects of the job, from carrying the financial burden of paying trucks every week to guiding a city? Because once a disaster hits, you don't know what you're going to face. There may be a tree laying on your wastewater plant. What do? You need a crane at that point, as opposed to a skid steer or just your traditional debris truck. So I encourage cities, think through this stuff in the off season, because when it happens, and you need to have proper contractors on your team that are nimble.
And guys, why do we think this is important, right? It's important for a number of reasons. One, obviously you want a contractor in place that actually has the know-how to do the work and actually has the technical and physical capability to do the work, right? But for me as a litigator, I also like to think about, if something goes wrong down the road, do we have documentation proper and in line with what FEMA requires in order to be able to present a case if we end up getting denied for reimbursement, right? I mean, Evan, you can probably talk a bit about, some of the hyper-technical requirements, and Raj too. We've dealt with that before in terms of leaners and hangers and tree canopies, and wanting them to, municipalities to document every limb past a certain number of inches or feet that are cut. That's a huge undertaking. If you don't have the right monitor in place, if you don't have the right contractor in place, you're kind of shooting yourself in the foot right off the bat.
And you have to document, even though there's no power during this whole scenario. In addition, when cities are selecting contractors, the back office is just as important as the guy out in the field. Do they have a data team? Is that data housed in a location away from your city so that in case their particular local office goes down, do you still have access to that data? Is that data still being collected, mined, properly stored? I walked into my office and I was managing the grants person, and I introduced myself, and there were all these boxes, just boxes everywhere. And I said, "What's that?" And she said, "It's Hurricane Irma." I said, "Ma'am, it's like 10 years ago."
It's probably yellowed paper by this point, right?
But point being, you don't want, if you have the right contracting team and monitoring team, you don't have these boxes just sitting around that are some hurricane a generation ago, because you're still fighting it out and looking for this one stump ticket that FEMA's requesting. You can digitize all this stuff, and the proper contractor and monitoring firm are already going to be set up to do.
Right, and just to kind of go off of that, I think, Roger, you're predicting this. When you say stump ticket, I mean, we're talking about requirements that FEMA imposes. We're talking about identifying a particular tree stump of a certain diameter, not to exceed a certain amount of diameter, that may have been ground down after a storm to get a massive tree out of the roadway so emergency services can cut through there, needs to be tagged, it needs to be geolocated, and it needs to be shown on a map where that is so that the cost incurred in order to grind that stump is reimbursable, right? So we are talking about, we don't want to see reams and reams of paper. We want stuff digitized, streamlined, because ultimately you want to be able to hand over all of that documentation on a silver platter to FEMA.
And this documentation requirement stems from the Public Assistance Program and Policy Guide, right? What we call the PAPA-G. Obviously, as a disaster recovery or disaster removal, right, debris removal company, DRC has to be intimately familiar with the requirements of the PAPA-G, but also, and you've mentioned it, and we've both mentioned it, right, or all three of us have mentioned it, is a debris monitor. How important is having a debris monitor? And do you recommend that cities do their own monitoring?
Never do your own monitoring, first off. You don't, the staffing that it takes to do debris monitoring is incredible. For every truck's got to have a monitor with it. Your debris management site's got to have at least 2 monitors there. And then once you get in the cut and leaners and hangers stumps, you're going to have a monitor with each of those crews as well. So even for a small city, this could be 30, 40 monitors at work at one time. If you don't have the right debris monitor, you are going to be in a paperwork nightmare for a very long time. Debris monitoring companies over the past few years have gotten very good at creating these automated debris management systems. So every time a load is picked up, every tree, every leaner, every hanger that's done, those tickets are made in the field. They're digitally made. They can be printed as a paper ticket to be submitted, but they're all digital, and they're all have a naming convention associated. So when you're looking for a ticket from October 20th, 2023 on 12th Street, you can find it with 4 or 5 clicks of the mouse, or maybe even 1 click of the mouse, as opposed to boxes and boxes of old tickets. So I encourage every city, you get a monitor, you hire a monitor, you do training in the off season with the monitor and the debris management contractor, and you're going to be in pretty good shape. You're going to be 80% down the road.
Do not rely on local staff.
I mean, look, it's local staff, of course, they're experts of their area, and they should definitely be helping. And I think it's actually invaluable for you, of course, Evan, to have someone on staff that's highly capable. But Justin, I know we've gone through the fire and the flames here, and looking through documentation that is prepared by a debris monitor with a really good disaster debris removal company, that's really key. If FEMA comes in and at some point says, pause, your public assistance request is denied, right?
Absolutely. We've seen both sides of it. We've seen those only paper tickets and maybe not, capturing every single cut, and then, the municipality asking for full reimbursement, and we've seen denials on that. And we can talk about it in a bit, but we've been successful in reversing some of those, and other times you kind of have to play the hand you're dealt, and there's only so much that you can do. That's why I say, from sort of the litigation perspective, whether it's in disaster relief or really in any type of situation, I think it's always good. Nobody wants to get a litigator involved until you're already at a certain point. But I think having someone, if not a litigator, an attorney, reviewing things along the way can really help you avoid missteps down the road and help you build the case early on by doing things the right way.
And I'll tell you, from the RFP point of view, the city attorney, the county attorney, the outside counsel, whomever, needs to be reviewing this RFP before it goes out, because if, as part of the Papa G, as we call it, you have to follow your local procurement ordinance. So if a procurement is done, even if it's above board, if it didn't follow the city's procurement ordinance, it's not proper. So having your attorney there before anything goes wrong is wildly important as well.
Yeah, and that often is the first thing that I tell folks right around this time in April and May. Hey, dust off your debris removal contractor contracts. Dust off your debris monitoring contract. Let's make sure that those are valid and that they've been procured correctly. And I don't know how many times after our experience, I've really been able to go to our clients and say, look, your debris contract is ending next year. Let's start putting that out on the street, let's say in December, so that we can start getting folks in place. And they know I'm going to be there to make sure that they have all of the federally required contract clauses, the references to the scope of work that will allow you to perform eligible work, right? Because the public assistance program and policy guide is onerous, right? But also that it's complying with local procurement, like you're saying, but also federal procurement, right? Sometimes our local procurement codes are very permissive because, of course, our municipalities and our counties need to be nimble. And sometimes they know the markets around them the best. But this type of service is not one that can be purchased through a simple request for a quote by an email, right? This really does require you to work with counsel, work with your experts in-house to develop a proper scope of work, develop a proper RFP document, and follow your own rules and federal rules at the same time. Do you have any advice on that aspect of the scope of work, though?
On the scope of work, you always want to, for example, I think Collier County has somewhere around 600 HOAs, whereas, North Miami might have 3. For Collier County, they're probably going to want to devote a section of the scope of work to how to deal with HOAs, private property, what have you. Whereas, North Miami, South Miami, somebody with less HOAs, sure, they need to have line items that are usable, but their scopes of work may be different. It's a much more urban environment. Costs are different. Disposal is different. Final disposal for debris coming from the east coast of Florida is likely not going to go in a landfill in Miami-Dade County. It's likely not going to go in a landfill in Broward County. Palm Beach County, they're kind of self-contained, but a lot of this debris is winding up going to Okeechobee with the lack of landfill space that the counties are faced with. So having a scope of work that accounts for distance becomes important on the east coast of Florida, whereas on the west coast of Florida, landfills have a little more space and they're more apt to take their own hurricane debris. So you just want to think through a lot of those solid waste and public works questions. Do you have culverts, inlets? Are there very small drainage ditches that may need to be redredged, regraded? Those are all things that you can do inside of this contract, but you have to know your city and you have to understand the art of the possible, so to speak. So I tell everybody, look at your city, look at what you need, look at what you know you need, and understand that you can't procure everything. There will be something that comes up that you had no clue about. I'll tell a quick story if you don't mind. I walk into an EOC day after Hurricane Ian.
So an emergency operations center.
Yeah, an emergency operations center. They're all in their stations, and I'm coming there to get my maps. I'm getting ready to start the first push. And I hear they're going around doing their EOC meeting and that the shelters aren't getting food. Meanwhile, the Peace River levee is broken and the water is continuing to rise even though the hurricane's over. So I was able to walk over to them and say, hey, we'll bring in meals on high water vehicles, but we've got to do this emergency contract. Now, they had a catering contractor that was not able to fulfill the contract at the time, but because we had a relationship, I understood the county, and things were going terribly wrong, we were able to step in and we wound up providing 28,000 meals in 7 days. You have to be able to be nimble and understand that these disasters evolve, but having the right team in place is your first best step.
And I know that emergency procurement probably had the legal counsel right on there, right? But now let's switch gears a little. let's assume that, okay, you've gone through, you've done the work, you understand the scope of what you need for your community, you've set up an RFP that incorporates all of the PAPA-G requirements, incorporates contract clauses. Do you recommend at the end of that RFP process awarding to multiple bidders?
I say pick a primary, pick a secondary, and pick a tertiary. That way, if the primary doesn't fulfill their contractual obligations, you can go to the secondary, you can go to the tertiary. If you just say one of with no ranking, you invite a process that is not to your benefit. So it winds up becoming, lobbyists get involved, you get a lot of top-down decision-making. You wind up with council members maybe saying, oh, I've known this firm forever, you should use them. Right. And then it becomes just a food fight. You set yourself up for failure instead of picking a guy, picking a company, and sticking with them and letting them guide you through. There are 4 or 5 companies in this industry that do this around the country. You pick one, you're probably going to be in good shape, because contractors, we don't follow money as everybody thinks we do. We follow commitments. First things first is I've got to go to the folks that I've committed to. And then everybody else can come after, but first things first, we have to deal with our commitments.
Got it. So we've gone through the RFP phase. We've awarded to 1, 2, and 3 contractors. They understand their commitment. They come in, they do the work. There's a monitor on the stage. The municipality or the county submits a request for public assistance from FEMA, and after years, they receive a denial of that request. And it can happen, even if you do everything right, out of misunderstanding or just simply not understanding the documentation that was submitted.
It can happen through an error on the municipality side, good faith error. It can happen based on an error of the FEMA reviewer. They have thousands of cases that they're reviewing each year for reimbursement requests, and they could be combining cases and be getting confused. At the end of the day, it's people sitting at the desk reviewing information. So
after the fact.
After the fact.
Right, they're not in the ground looking at the canopy that fell down.
They're looking at what you provide, which kind of all goes back to what we're saying, right? Is why you have to get your ducks in order early on. So what happens if, I think, Raj, I'm going to pick up from there. Yeah. What happens if you get denied, right? Through all best efforts put forward, what are your options? So this can be many years down the road, right? By the time you get the denial, FEMA is slow, and they're a bit short-staffed at the moment as well, and they take a long time sometimes to give you an answer here. So what do you do? Well, your first option is called a first appeal, right? We've had experience in this. First appeal is basically an opportunity for you to gather your team together. Sometimes it can include even a contractor liaison as well, which we kind of encourage as well. If monitoring companies were involved, as they should have been, you have a meeting. You look at the determination memorandum, the denial in this case, or partial denial from FEMA, and you analyze it closely. You pull any documentation that you think was not submitted, or that any additional documentation that you think could be helpful, gather that together, and you want to address line by line, point by point, every issue that FEMA makes in their denial. If you leave anything unaddressed in your first appeal response, written response, they go for low-hanging fruit. They are strapped for time. They will deny your appeal.
So things like the contract not having the right federal provisions or not being procured correct.
Correct. They will go for low-hanging fruit. So you want to be as thorough as possible, get your team together, and put together the clearest, most concise first appeal written response that you can. You put that together. You submit it. You cite to whatever sections of the PAPA-G, the Stafford Act that you need to cite to support your case. FEMA has time to file a response. And get back to you on what their answer is. They can request additional information, technical advice. They do that, we find, usually, right, to give themselves more time to respond. Sometimes they're not really asking for much more, but they need more time to respond. So they'll do that. Ultimately, they could either reverse their earlier decision and grant you reimbursement.
After a long time.
After a long time. I mean, we're talking, at this point, you could be over 200 days into this from the time that you submitted your first appeal, the way that they can drag this out. So let's say they deny you again. Then what do you do? Well, depending on where you are in the process, right, you're kind of at a fork in the road, right?
Right.
So depending on a number of factors.
You can appeal to the lion.
Right.
So to speak.
So how many of you out there would say, okay, I got denied by FEMA the first time, I submit a written appeal, first appeal, I get denied by them again. How many of you out there would want to submit a second appeal back to the lion Back to the Goliath and the David versus Goliath fight. I don't think anyone would, right? Well, if you qualify, which means typically you're seeking reimbursement for over $500,000. There are other provisions in there, but typically speaking, you can do what's called an arbitration with the Civilian Board of Contract Appeals. And Raj, we've dealt with them before. This is a board that has been around a while, but in 2018, they were given jurisdiction to hear these types of FEMA reimbursement appeals for emergency declarations. So we've handled these before. It's a 3-judge panel, arbitration panel. And the most important point I think it's worth making is we recommend, every case is different, but we generally recommend if you qualify for arbitration after that denial of the first appeal, 99% of the time you should take it because it's the first and only opportunity in the entire appeals process to actually appeal to someone other than FEMA. Right. It gives you a chance to go in front of a 3-judge panel, so that's 3 independent minds that are segregated away from FEMA to look at everything, the record that you've built from the beginning and make an impartial decision, right? Which is why the first appeal is so important, even if you get denied, because the board is going to look at it, right? They allow evidence. The rules of evidence are very loose in these hearings. So you can submit new evidence. You can submit affidavits, you can depose witnesses at the hearing. All stuff that wasn't in the record before, you can put in.
But that still means you do have to have documentation showing that your debris removal company and your monitor were collected.
That's why I kept chiming in earlier, because if you're not given the tools, if you're showing up to a gunfight with knives, you're really at a disadvantage. The ultimate goal, assuming you don't prevail on the earlier rounds, is to prevail in front of the arbitration board. If you don't come there with the proper documentation, they're also going to look at the package. They're going to compare and see, did you comply with this? The benefit, though, is that, like I said, you have 3 independent judges, and you also, it's really the only time that you have the ability to make what are called equitable arguments, fairness arguments. And we've found that in cases that we've handled and also in decisions that have been handed down in other matters, they do tend to at least factor some fairness argument into it. If a city, for example, does 80% of what the package asked in terms of trees and stumps and whatnot, it's not going to be like FEMA where they're just going to deny you outright. Maybe you'll get 80% of your costs back if you've done 80% of the work. Maybe they'll give you even more. We've been successful in overturning a 0 award from FEMA originally to several $1 million. So
and that's obviously not a guarantee because it's all based on documentation.
Absolutely, every case is different. But if you show up with the right materials, you can make a good argument. And I recommend, and I think Raj, you do too, at that point, if you haven't already, you definitely want to get your attorneys involved. You do not want to show up to an arbitration just with city staff, municipal staff. You want an attorney, a litigator, or an attorney that is somewhat familiar with arguing in front of administrative boards, because there's sort of an art to it, to go to DC and make the argument. So at the end of the day, you have a mini trial. If you prevail, great. Then you get your reimbursement, either whole or in part. If you lose, that's the end of the road. And then you hopefully learn from your mistakes the first time and get your monitoring in the next time. Get your contractor, like what Evan said, don't just hire 5, do a number 1 priority and maybe a second or tertiary backup.
Right, and always have a debris monitor, right, and procure correctly from the get-go. So really, yes, it's helpful to have the legal counsel at the appeal stage, but hopefully you never get to that, right? Hopefully you've procured it correctly, you've gotten a good team on board, it's been prepped, you've done the pre-planning, and then good post work, and everything is documented. But if it ever comes to it, at least we know there are appeal procedures beyond appealing to FEMA.
You have options you hopefully will never have to use.
Yeah.
Thank you all for tuning in to today's episode of The Intersection. We hope this conversation gave you a clearer understanding of the FEMA public assistance process and what it truly takes to navigate recovery after a disaster. For the municipalities and public officials listening, one of the key takeaways from today's conversation is that the decisions you make before a disaster and the steps you take in the immediate aftermath can have a significant impact on your ability to recover FEMA funding. Understanding the appeals process and the packaging before you need them is not just helpful, it's essential. Whether you're a city manager, an emergency manager, or a public sector attorney, we hope today's discussion gives you a clearer roadmap for what to expect and how to advocate for your community when it matters most. Until next time.